Dear students, this is not a new lecture. Actually, it is an extension for the previous lecture. So, in the previous lecture, I reached the point which is it a condition to have nationality having the state? And I told you that the state existence is a condition for having the nationality. Since, according to the definition, the state is one of the pillars for defining the nationality. So if there is no state, no nationality, there will be incomplete nationality or inexistent nationality. This is better. Well, however, the question which is important here, in my opinion, is it required that the state which grants the nationality be fully sovereign or sovereign state to grant the citizenship or even the nationality? I mean, if Palestine would like to grant the nationality for its nationals, is it a condition that Palestine shall have full sovereignty? In other words, if Palestine is under the mandate, the British mandate, does that affect on the matter of the nationality which can be granted by the state to the nationals? Well, this is the question here. Well, all is required to grant nationality is having the statehood character. However, if the state doesn't have it, doesn't enjoy it, then there is no nationality. But if there is the character of the state, then the state can grant the nationality to the nationals of it. However, if the state here is under one of the systems of the protection, guardianship, or the mandate, does that prevent the state from granting the nationality? Well, no. The answer is no, because these matters do not affect on the character of the state. What matters is that we have the character of the state. Now, if the state is under one of the systems, I mean the protection, guardianship, or mandate, it doesn't affect on the issuance of the nationality, granting the nationality, or whatsoever. So the state, when it is under one of these systems, it still have the right to issue laws or national laws. One of these laws is the nationality laws. So this was the case in Syria and Lebanon. They were under the French mandate. Palestine and East Jordan, they were during they were under the British mandate. Tunisia and Marrakesh under the French protection. So these territories, they were having and enjoying the international character. They were considered states, but they are under the protection or guardianship or mandate systems. So they have the state character. So they can grant their nationality. They can promulgate laws regarding the nationality and regulations regarding nationality. So it doesn't count whether they are under the protection system or not, guardianship or not, mandate or not. What matters is that they are states. They are real states, so they can do whatever they want regarding the nationality. As for territories that do not have the character, I mean, when the territory is not considered a state, it is not admitted as a state. For example, the colonies or even the territories that are annexed officially to another state, like what happened in Algeria when it was annexed to the French occupation, and they were considering it as part of the French state. Then in this case, they cannot issue laws regarding the nationality. So as mentioned here, the members of the annexed territory, they do not have the nationality, and independent, they do not have independent nationality because their state is not independent, their state is not sovereign even. Rather, they belong to the country of which the region is part of, such as Algeria under the French occupation, where it was annexed to French officially. That's why in this period, the annexation time, even if it is not legal, it is against the rules of international law. However, that period it was. So that period, there was no ability for the country to issue laws regarding the nationality because there is no state. I mean, in the literal meaning. However, in our opinion, this is not actually my opinion. It's the opinion of Professor Mu'taz Kufeisha. Uh, is the dean of Faculty of Law in Khalil University. He says that the nationality which is issued by states lacking the sovereignty, I mean, when they are under one of the protection or the guardianship or even the mandate system, he says that there remains a diminished nationality. هي عبارة عن جنسية منقوصة since there is no country in every sense of the word to grant the citizenship. It is the government of the dominant state. I mean, the state, the protective state, or the protector, or even the guardian state. They are the countries who controls the issuance of the nationalities laws. That's why he considers that the citizenship is in this case a diminished one. Okay, so this is regarding the question: is it required that the state be fully sovereign to grant nationality? Is one of the most important questions you have to focus on it when you read for your exams. The question now here, or there is another note before we end. It says, it should be noted that there is no requirement for legislation to regulate nationality in order for citizens of the country to be considered possessing its nationality. So, the point that he wants to deliver here is that if there is no law issued by the parliament regarding the nationality, this doesn't mean that there is no nationality for the people of the state. He says that the state or the nationals of the state can be considered nationals and they have or enjoy the nationality of the state despite the fact that there is no law which grants the nationality or even regulates the matter of the nationality. And he gives example that in ancient time or the middle areas, there were often no written laws regulating the nationality. Yet, no one can deny that the nationality was existed for the citizens of the country. Like, for example, the Ottoman Empire, it was a state. It is a big state. However, they used, I mean, the people in the Ottoman Empire, they used to be nationals and they belonged to the Ottoman Empire, and they used to be treated as nationals, despite the fact that there was no written law regarding the Ottoman nationality. And they used also in the practical field to differentiate between those who are citizens of the empire and the foreigners who dwells temporary in the on the territory of the Ottoman Empire through what is called the foreign privileges. من خلال الامتيازات الأجنبية كانوا بيميزوا بين الشخص الأجنبي والمواطن. Despite the fact that there was no there was no written law regarding the Ottoman nationality. So this is why it can factually exist. I mean, the nationality can factually exist without the existence of a written law. And this is what is called the de facto nationality. الجنسية الواقعية انه انت لك جنسية رغم انه ما فيش قانون بينظم موضوع الجنسية. So this is regarding actually the overview on the nationality as one of the subject matters of private international law. If you have any questions regarding this part of the lecture, you just leave me a comment on the YouTube channel videos, or even you can send me email to my email, which is shown here. Mm, Now I will move to another topic. It is the state jurisdiction on the matters of the nationality. So I would like to share it with you. موضوع الآن يا جماعة بيتحدث عن يعني سلطة الدولة واختصاص الدولة في تنظيم موضوع الجنسية أو المسائل المتعلقة بالجنسية. يعني كأنا بقول is the state enjoying or does the state enjoy the the full jurisdiction or the absolute jurisdiction in regulating its nationality, or the state shall have quasi absolute jurisdiction regarding regulating the nationality matters. So the question here is about this matter, whether the state has absolute jurisdiction or quasi absolute jurisdiction on regulating the matters of the nationality. Well, I will start with the fact, with the answer immediately, that the state do not enjoy the absolute jurisdiction regarding the matters of the nationality. They enjoy what is called and described as quasi-absolute jurisdiction. الدول تمتلك يا جماعة يعني شبه سلطة مطلقة في عملية تنظيم مسألة الجنسية، بس مش مسألة مطلقة. لأنه إذا بدي أقول في سلطة مطلقة معنى ذلك في إشكاليات راح تترتب على هذه السلطة المطلقة حنذكرها فيما بعد. So why do we say that the state has quasi-absolute? Why the absolute here is found? Because the population is considered one of the pillars of the state. And this pillar is something that concerns the state policy to increase the number of the population or to decrease the number of the population is one of the matters that concerns the state policy. So to adjust this number by increasing it or decreasing it through the system which is adopted regarding acquiring the nationality is one of the matters that fall under the quasi-absolute jurisdiction of the state. That's why Article 1 of the Hague Regulations 1930, I mean the Hague Conventions, reads that every state has the right to determine who is national according to their domestic law. So it's clear now that every state has a right, but they did not like put a description for that right, but you can say that it is a quasi absolute right to determine who's national according to the domestic law. Okay. Now, also the committee, I mean, the established committee for purposes of codifying the international law rules in 1927, it confirms that the nationality follows the sovereignty of the state. So it's clear now that the state has sovereignty. The state has jurisdiction to determine on the matters of the nationality. Even the ICJ, as one of the judiciaries, it affirms that, or this meaning, in its advisory opinion in the conflict between France and England, it says that nationality matters fall within the matters of Article 2, Paragraph 7 of the United Nations Charter. Do you still remember the essential domestic jurisdiction? When we studied the organization or the law of the international organizations, I told my students that Article 2 is one of the most important articles within the United Nations Charter. So Article 2, Paragraph 4, it talks about the prohibition of using the power in the international relations. However, Article 2, Paragraph 7, it was talking about the essential domestic jurisdiction, نطاق الاختصاص المحفوظ للدول. أن الأمم المتحدة بتعترف إنه في مسائل من ضمن الاختصاص المحفوظ للدولة اللي مش ممكن أي حد يتدخل فيه باستثناء تلك الدولة هي اللي بتنظم هذه المسائل. One of these matters is the nationality. So even the United Nations considers that the nationality is one of the domestic essential jurisdiction of the state, and it reflects the sovereignty of the state. Same meaning was reaffirmed in the case of Nottingham 1955, and I will give you explanation and more details about the Notre Dame case when I came to it in the coming lectures, when I come to it, okay? So this is regarding the state's right to regulate the matter of the nationality. Now, if the state is allowed to regulate its own nationality, this means that, in the other words, the state is not permitted to intervene in the regulation of the other nationalities or even to intervene in the other states' nationalities. So if the state can determine who is national or not national regarding its own nationality, it is not permitted to do so regarding the nationals of the other states. Let me give you an example. Now, there is Article 14 of the Bolivian Civil Code. The Bolivian Civil Code, Article 14, it talks about one of the matters of the nationality. It says, a Bolivian woman who marries an alien shall acquire her husband's nationality. يقول لي المرأة البوليفية إذا تجوزت من شخص أجنبي يجب أن تكتسب جنسيته. مين قال لك تتدخل في الموضوع؟ مين قال لك إنه لازم يكون في إلزام على الدولة الثانية إنه تمنح المرأة هذه البوليفية الجنسية؟ يعني كان بيقول لي a Bolivian woman which marries a Palestinian shall have the Palestinian يعني nationality. Now, it is not your jurisdiction to decide whether Palestine shall grant the nationality to your woman or not. So this is intervention from the Bolivian law in the affairs of the other nationalities or the other states' nationalities. So this is an example for something prohibited under the Hague regulations, which says that the state can have jurisdiction only on its nationality, on the field of its own nationality. However, it cannot intervene on the nationals of the other states or the nationality of the people of the other states. Okay, so this is against the rules of the nationality. However, when the state practices its right regarding regulating the matter of the nationality, it shall not have absolute right, because if it has absolute right, it would lead to some troubles regarding the statelessness case, the dual nationality, and this is actually these problems. I mean, the statelessness and the dual nationality are considered the ones of the most complicated problems in the international arena. So that's why we can say that the state doesn't enjoy absolute jurisdiction; they have quasi-absolute jurisdiction. So there are some limits which turn this absolute jurisdiction into a quasi-absolute one. These limitations are in favor of the individual, or even they are in the favor of the other states. Um, أحيانا بيكون القيود اللي فرضت على موضوع اختصاص الدولة بتنظيم الجنسية لتحقيق مصلحة يا الفرد نفسه يا لتحقيق مصلحة الدول الثانية. في كل الأحوال هذه القيود المفروضة على اختصاص الدولة في تنظيم الجنسية هي اللي حولته من اختصاص مطلق إلى اختصاص شبه مطلق. عشان هيك من بداية المحاضرة قلنا اختصاص الدولة بتنظيم موضوع الجنسية هو اختصاص شبه مطلق، لأنه في بعض القيود أحيانا ترد على سلطتها، يعني بما لا يؤدي إلى إحداث هذه المشكلات، مشكلة انعدام الجنسية ومسألة تكرار الجنسية أو ازدواجها. يعني على سبيل المثال، لو أنا اليوم قانون فلسطيني بيقول كل مرأة فلسطينية تتزوج من شخص أجنبي تفقد جنسيتها الفلسطينية دون استرجاع في أي حال من الأحوال، فراحت اتجوزت واحد أردني وكان القانون الأردني بيعطيها الجنسية في حال وجود علاقة الزوجية، اتطلقت منه، عمليا تكون قد فقدت جنسيتها الأردنية اللي اكتسبتها بالتجنس عن طريق الزواج، وبتكون فاقدة الجنسية الفلسطينية، فهذا بشكل مسألة انعدام الجنسية. عشان هيك من ضمن الليميتيشنز اللي بتنحط على القانون الوطني انه يجب ان تخفف من الحالات اللي انت بتعتبر الشخص فيها فاقد للجنسية بدون استرجاع، لانه ممكن تسبب لي مشكلة انعدام الجنسية. فهذا القيد لما انا بحطه بيكون in favor of the individuals، او خلينا نقول انه the Palestinian woman when she marries a Jordanian person. In this case, she keeps or she still keep the Palestinian nationality, and she acquires another nationality which is the Jordanian one. So it has double nationalities or dual nationality. So in this case, it is a problem. The dual nationality is a problem. And this problem, it doesn't affect only Palestine, it affects the Jordanian law and the Jordanian system, because it would lead in some conflicts to a conflict of law. فليش توجعني في مسألة الكونفليكت اوف لو يكون في تعدد جنسية أصلا؟ فمسألة القيود الموضوع عشان تمنع الدول nationality برضو هي in favor of the other states. So the limitations in the favor of the individual يعني تتلخص بفكرة الليميتيشنز في موضوع الانديفيدوال في أول حق بيمتلكه الفرد بأنه the individual has right nationality according to article 31 of of article 31 of not article 31, it's wrong number actually, it's article 15 of the UDHR, which says that everyone has a right to nationality and he cannot be arbitrarily deprived of his nationality or denied his right to change it. The right of the individual to change the nationality, the inability to arbitrarily deprive a person from his nationality. So these must be taken into consideration from the state when it regulates the nationality law. Uh, Besides the other limitations regarding which is in favor of the other states or the in favor of the individual. I will be talk about these limits inshallah also in the coming lectures. Actually, you have to know, or if I do not illustrate what are these limitations, all you have to know is that the limitation which is put on the shoulder of the state in regulating its nationality laws, that it must consider the points which doesn't lead to the problem of the dual nationality or even the statelessness cases. That's it. You do not you do not have to memorize or to keep something else. That's all you have to know. Okay. Well, to this end, I end my lecture. In the coming lecture, inshallah, I will be talking about the problem of the statelessness. حتكون موضوع كبير أو موضوع مهم، موضوع انعدام الجنسية، على اعتبار إنه من أكثر المشاكل اللي بتواجه موضوعات الجنسية على الصعيد الدولي. بإمكانكم أنكم تحضروا الجزء السابق من هذه المحاضرة، لأنه هما جزئين. هذا الجزء الثاني. الجزء الأول بإمكانكم تجدوا في الأيقونة اللي حتظهر أعلى الشاشة، أو بإمكانكم تحضروا من خلال الفيديو الموضوع على هذه الشاشة. شكرا لكم جزيلا، وأترككم في أمان الله وحفظه، والسلام عليكم ورحمة الله وبركاته.